On Thursday, the court held a hearing on Trump's motion to dismiss all of the claims in his Georgia RICO action. Now, this motion to dismiss was based on the First Amendment, and Trump was essentially arguing that all of the conduct that the state alleges in the indictment is core political speech, and therefore it's protected under the First Amendment. As such, the protected conduct can't be the basis of a criminal indictment under any of the statutes under which the state has brought charges against Donald Trump. Now, in order to understand this argument, we have to have an understanding of how these First Amendment analyses are played out in the court. So there's two ways that a litigant can challenge statutes under the First Amendment. The first is called a facial challenge. Now, under a facial challenge, the litigant would essentially say there is absolutely no set of circumstances under which this statute is permissible under the First Amendment of the Constitution. Therefore, the statute is invalid. That's not what we have here. Trump's attorneys have already agreed that the statutes that he is being accused of having violated are on their face valid statutes. So it's not a facial challenge. What we have is an as-applied challenge. Under an as-applied challenge, the litigant is arguing that even though this statute is valid, as the state is applying it under this set of circumstances, it becomes invalid. Now, under this as-applied challenge, the court essentially has three things that it has to deal with. First, because the as-applied challenge is dealing with the circumstances of what went on here, it's kind of a factual inquiry. So the court first has to determine, is this issue ripe? Is this the right time for the court to be deciding an as-applied challenge? Given that at this stage in the litigation, the factual record hasn't been developed. The second thing the court has to decide is, okay, assuming that this is ripe for review at this point, am I confined to the allegations in the indictment, or can I look outside of the indictment and kind of bring in other evidence? The third thing that the court has to decide, of course, is assuming that we reach all of this today, what do I do with it? How do I decide whether or not Donald Trump's First Amendment rights have been violated under this indictment? So before we get into the hearing itself, there's one case that we have to take note of, and that is Giboney versus Empire Storage and Ice Co. That's a 1949 U.S. Supreme Court case that essentially held that speech that is integral to criminal conduct loses its protection under the First Amendment. That case is still good law. The U.S. Supreme Court cites to it all the time, as do lower courts. With that, let's see how the court dealt with the first two issues it has to decide.
What also seemed clear, even reading Hall, is that if we're in making an as-applied challenge, we're within the confines of the indictment because unlike Hall, the state hasn't said, here's some additional facts that we're willing to stipulate to or concede to or anything like that. Any and all of that, any reactions?
I understand how the court could look at the inverse, but I think as written, with all the justices agreeing that it is a First Amendment challenge, would be ripe, constitutional challenge on the First Amendment grounds, as long as we accept all the well-pleaded factual allegations in the indictment and don't go beyond those.
So Donald Trump's attorneys are basically saying, this issue is ripe right now. The court can reach it. But they do concede that all the court can look at is the well-pleaded allegations in the indictment. The court cannot go outside of the indictment. Let's see what the state has to say.
It would suggest that an as-applied challenge cannot succeed under the First Amendment because speech integral to criminal conduct is not protected. A well-pleaded indictment is going to demonstrate that speech that is pled as part of a criminal charge is integral to criminal conduct. And so there's nothing to decide if you're looking and you're cabined by the indictment. So we sort of have two routes here. Neither of them result in the grant of this motion. One says, the court says this is premature, there's questions that have to be answered. Any First Amendment challenge has to happen after there's a factual record to look to. And the other says, okay, I can get to this today. It's not that I can't. I can, but there's nowhere to go because all of the speech is pled as integral to criminal conduct, and therefore it's not protected by the First.
So here the state is saying, well, finding that this issue is ripe under an indictment where we've alleged that speech is the basis of criminal conduct is preposterous because there is no First Amendment protection for speech that is the basis of criminal conduct. But finding that it is ripe gets us to the exact same place. So sure, court, go ahead, let's do it. And at this point, the court kind of just assumes that this issue is ripe and moves on.
All right, so back to you, Mr. Sadow. Let's move forward with the idea that we're making an as-applied challenge solely confined to the indictment. This isn't a facial challenge. You're not saying any of these statutes are on this face
Correct.
Unconstitutional. And your argument is that this is core political speech.
Correct.
So some crimes can be achieved solely through speech, though. Terroristic threats, solicitation. Why is that not what's happening here as alleged?
So here the court is pointing out that speech that underlies criminal activity under a multitude of valid statutes loses its protection. So how is Trump's attorney going to deal with this? Well, essentially what Trump's attorney is going to argue is that because this is political speech, and political speech essentially never loses its First Amendment protection, well, you can't criminalize what Donald Trump was saying because it's political speech. Let's listen.
So the first thing we have to decide is whether or not, and we're talking about President Trump, we're not talking about the actions of others. We have to look and see whether or not that which has been alleged as facts is in fact core political speech, political discourse, protected speech at its zenith. I don't think there's any question that statements, comments, speech, expressive conduct that deals with campaigning or elections has always been found to be at the zenith of protected speech. What do we have here? We have election speech.
So Donald Trump's attorney is correct in this regard. Political speech does have a heightened level of protection over other types of speech. In fact, the Supreme Court itself has used the word zenith to describe the heightened level of protection that political speech receives. But that doesn't really get to the point because Donald Trump's attorneys never cite any authority standing for the proposition that political speech, when it's used to form the basis of criminal conduct, doesn't lose its protection under the First Amendment. The Supreme Court, nor any other court, has come out and said, look, while all other speech that forms the basis of criminal conduct has lost its protection, political speech stands in a place all on its own, and political speech can never form the basis of a criminal indictment. That's not what any court has ever said, and so Trump's attorneys can't point to any case law for that proposition. So with that in mind, let's see where Trump's attorneys go next.
So then the question becomes, is the mere fact that the state here represents that it is false or fraudulent under the statutes, is that enough? Now, one I just heard, I think the state's position would be yes. All we have to do is say it's false, it's integral to criminal conduct, it's fraud, and therefore it can't be unconstitutional as applied. I don't believe that that's what the law says. I think what the law really looks at is as to each individual application of a statute, whether or not the falsity in and of itself alone is sufficient.
So what Trump's attorney seems to be arguing is that if the only allegation under the indictment is that the claim was false and therefore it's criminal, then the statute is, as applied, invalid. But that's the essence of a facial challenge, and that's not what we have here. And in fact, SCOTUS has already determined that false speech is not necessarily unprotected. So the reason that Trump's attorneys are trying to go this route is because if they can cabin this as the state is just trying to impose restrictions on this speech for falsity's sake, just because we don't like false statements, well, then it goes against Supreme Court precedent. And so this is going to get into a case of United States v. Alvarez. So let me explain to you what that case had to do with so that you can understand what the attorneys are going to be arguing here. So this is a 2012 case that actually cites back to Gibbons, which I pointed out earlier. In this case, a man by the name of Xavier Alvarez was a known liar. He lied all the time. And in one instance, in a public statement, he lied about the fact that he had been a Medal of Honor recipient. Now, this lie was in violation of the Stolen Valor Act, which criminalized any false statements regarding the receipt of a congressional or military award or honor. So his defense to his criminal case was, well, the statute is invalid because this is a content-based restriction on speech that no matter how the state enforces it, it's going to run afoul of the First Amendment. So the government, on the other hand, in defense to that argument says, well, no, because the Constitution doesn't afford any protection to false statements. So as the Supreme Court was dealing with this case, they actually point out several different statutes that are widespread. Many states have them. The federal government has them, under which false statements can be criminalized. And those include where the government officials regarding government matters have been lied to. So you can't make false statements to government officials regarding government matters. Second, you can't commit perjury. That's an abridgment of your First Amendment right. You should be able to lie, right? Well, not when you're perjuring yourself. The third place is where you're falsely representing that you're speaking on behalf of the government, or you are impersonating a government officer. So at least with respect to those three types of statutes, they are presumptively valid. But the court did say that these are valid in part because they have a mens rea requirement, meaning they always have something that says it has to be a knowing false statement or something like that. And the statement has to be material. So if you're on the stand in a breach of contract case and you say, no, Your Honor, I didn't breach the contract. And by the way, the sky is green today. Well, the fact that you said the sky is green today is a false statement. And you knew it was a false statement when you made it, but it's not material to the breach of contract action. So you're not guilty of perjury because you don't meet the materiality element. But in this case, the court squarely rejected the notion that false statements automatically lose their protections under the First Amendment. And so that's kind of what Donald Trump is latching on to here. So with that, now that you understand Alvarez, let's hear what Donald Trump's attorneys had to say next.
That's the beginning part of plurality, saying the way to attack false speech or false political speech or core speech is with truth. It says even a false statement may be deemed to make a valuable contribution to public debate since it brings about the clear perception and the livelier impression of truth produced by its collision with error. So this is the proposition that it's not the falsity alone that controls. It's the context in which the speech is made. And if it is deemed false, and for purposes of the indictment, we have to assume that it is false because that's what the facts have been alleged. That doesn't mean it's the end of the analysis.
Here, Trump's attorneys took an isolated quote from Alvarez and basically argued that false statements are a political good because they lead the public discourse toward a place where the public can arrive at the truth. The problem is that the court at that point in the Alvarez decision was analyzing why it is unconstitutional to criminalize falsity for falsity's sake and then offering reasons why that can't happen. But here we're not dealing with statutes that criminalize falsity for falsity's sake. We're dealing with statutes that only deal with specific instances where falsity lead to damages to the government, to the administration of justice and things like that, and leave all other false statements perfectly legal. So it's not criminalizing falsity, it's criminalizing conduct that causes damage where that conduct happens to be false statements. So Trump isn't answering the pertinent question here. And the pertinent question is, given that the statutes are valid, do these allegedly false statements fall under the penumbra of these valid criminal statutes? But Donald Trump doesn't want to accept the criminal allegations in the indictment. He's accepting the falsity allegations in the indictment, but doesn't want to accept the criminality piece of the indictment. Let's have a look.
Why do we not also have to assume, since it's an allegation, I think you say in your brief, that it's unlawful, willful, and knowingly false?
So, because at least our position, President Trump's position, is those are not words of fact. Those are words of legal connotation. And that while they have meaning, that would allow, for example, let's go to Alvarez in the Stolen Valor Act. Just because they alleged that it was unlawful didn't mean it wins. That is, it doesn't mean that the government wins.
But that's because they decided that wasn't a crime at all. I mean, that was a facial challenge where they said this statute, even if you violated it, violates the First Amendment. You've said that the RICO statute, you can violate it and not, it's not right? So we put legal conclusions in indictments all the time. I think that's going to be part of Mr. Schaefer's argument in just a minute. I mean, you said a moment ago, just because the state pleads it, you don't think that's enough in an as-applied challenge. And I'm trying to figure out why.
As to statements such as legal conclusions are unlawful and so forth.
So understand what Donald Trump's attorney is arguing here. The prosecutor has to allege that the false statements underpin the criminal conduct. Otherwise, there would be no indictment. But Donald Trump wants to do away with all of the allegations that the conduct is criminal. And that leaves us only with the falsity of the allegations. And if the falsity of the allegations is the only thing that's in the indictment, then the indictment is criminalizing falsity, which the court in Alvarez said is unconstitutional. So by taking all of these criminal allegations out, you have no choice but to dismiss the indictment. If this argument were to prevail, then that means that every statute that criminalizes false statements, the utterance of false statements, no matter what damages it causes, even those statutes that the court in Alvarez said were presumptively legal, it would decriminalize all of those. It would basically undo decades of Supreme Court precedent, including Gibney, including Alvarez. That obviously can't be the result here. So let's see what he has to say next.
Essentially, the state's position is because, as alleged, what President Trump said speech-wise or expressed either through his speech or conduct, which is still freedom of expression, because that's false in the eyes of the state, it's lost all protections of the First Amendment. And the concurring opinion and the dissenting opinion in Alvarez suggests just the opposite. If anything, under the circumstances, it needs more protection, not less protection. What the state wants to do is say, we have a goal. We have an objective here that we put forward. Steal the election in an unlawful fashion. I say change that for a second to legitimate concern about the validity of the election. If that was the way you focused on it, which is a way to do it as applied, even with the facts, would what President Trump said on those counts be a protected speech? And the answer is it has to be, because the only thing that makes it fraudulent is the state saying it's false. Take every one of those and say, okay, it's not false. It's protected. The only reason it becomes unprotected, in the state's opinion, is because they call it false. And that's what Alvarez doesn't allow. In and of itself, it cannot be simply the content-based. It has to be contextual. And the contextual here is a political core value being addressed, elections and campaigning.
So here Trump's attorneys are attempting to alter the indictment. The indictment essentially alleges that Trump made false statements in furtherance of a criminal enterprise. What Trump's attorneys want the indictment to say, or how they want the court to cabin the indictment is, well, let's switch that to true statements made in furtherance of political goals. So the problem here is twofold. So let's assume that at the time Donald Trump was making statements that he thought was true in furtherance of political goals. Well, to make that assumption, we are interfering in the province of the jury. It's the jury's job to decide truth and falsity. It's a fact inquiry. It's also the jury's job to decide mens rea. It's their job to decide whether these statements were knowingly made. So it's a two-pronged problem that Trump's attorneys are facing with respect to trying to change the indictment, alter the indictment. And that's kind of the reason that the state in the beginning said, look, either way you go here, either you can't reach this now because you have to get to a fact inquiry, or you can reach it now and you're stuck with the facts that we alleged, which means you might as well not have reached it now because you can't dismiss. So why are we even here? And that's the problem that's going to pervade this motion. We're just not there yet. We're not at the point where we can make factual determinations because the factual record hasn't been established. So now that we've heard from Trump's attorney regarding whether or not Trump should be released from this action because it was all political speech, let's see what the state has to say about it.
He's not charged under 161020 because he told some lies. Although it is very interesting to hear counsel for Mr. Trump tell us about the usefulness of lies. He's not being prosecuted for lying. He's being prosecuted for lying to the government, an act which is illegal because it does harm to the government. That's the reason that it's illegal. That's why it's different from the statute evaluated in Alvarez. Same thing with filing a false document. It's not just that you made a false statement. It's that you swore to it in a court document and submitted it to the court. That does harm to the judicial system. That's obviously different from just falsity being punished for its own sake. And that is what each and every charge in the indictment demonstrates, is that these statements are part of criminal conduct that is larger than just the false statement on its own, especially with the RICO charge, where what we see is that this is a criminal organization whose members and associates engaged in various criminal activities, including but not limited to false statements and writings, impersonating a public officer, forgery, filing false documents, influencing witnesses, computer theft, computer trespass, and on and on and on. It's not just that he lied over and over and over again, as counsel for the defendant points out by listing all of the instances in the indictment. It's that each of those was employed as part of criminal activity with criminal intentions. And we finally get to a place where where I knew we would end up, which is saying, I believe Your Honor was requested to think about it as not as lies, but as legitimate concern about election issues. Well, that sounds like a trial argument to me. But this is why I began by talking about intent with Your Honor, because I knew we were going to end up in this exact place where he said, sure, you can look at them as lies because they weren't true, or you could think this is just well-intentioned concerns from an American citizen speaking his mind.
So here the state is pushing back on the notion that the state is criminalizing falsity for falsity's sake. The state is arguing that the statute's criminalize lies that are detrimental to the administration of justice and or that affect government action. So these statutes are permissible, and when you violate them, you can't hide behind the First Amendment. That's what the Supreme Court has already decided. But the state goes on. Let's see what they have to say next.
And finally, the fact that it speaks to political concerns or core political speech, and this is something that the court in D.C. Thoroughly addressed, does not change the fact that it can be employed as part of criminal conduct. It's the mere fact that you're talking about issues of public concern or core political speech, which may be completely fine and protected in most contexts, does not mean that you cannot be indicted if you use that kind of speech to pursue illegal activities. That's the whole nature of the question. So it's very circular, and I would direct Your Honor to page 6 to 7 of the post-hearing brief filed by Defendant Trump, which says, the speech integral to criminal conduct exception of the First Amendment does not apply here because all the charged conduct constitutes First Amendment protected speech. That is a very neat circle.
Again, there is no precedent standing for the proposition that political speech somehow retains its First Amendment protection, even when it is integral to a criminal enterprise or to criminal activity. There is no precedent for that. So what is the court going to do here? Well, I imagine the court's going to do something like this. It's going to say, look, I can review this now. This is ripe for review at present. But I am confined to the four corners of the indictment. And based on the allegations in the indictment, Donald Trump made false statements in furtherance of a criminal enterprise. He made false statements that violated criminal acts of their own accord. And he engaged in conspiracies with respect to those false statements. Under those facts, as alleged in the complaint, I cannot dismiss the complaint because once these statements were used in furtherance of criminal activity, they lost their First Amendment protection. However, this opinion only has effect as of now. As the record gets established, as we flesh out these facts a little more, there is no prejudice to Donald Trump re-raising these motions. So what I mean by that is the court is likely to allow Donald Trump to re-raise these same arguments at summary judgment and at trial motions, at dispositive motions during trial. So we're likely to see these issues raise their head again. And we're even more likely to see that if all of the other things that are impediments to trial are overcome, then we're likely to see that this goes to trial, that Donald Trump's attorneys raise these as trial motions, raise these same arguments as trial motions, and that the court is going to defer ruling on them until after the jury has deliberated. And at that point, all of the work has been done on this. So Donald Trump essentially has no relief from these criminal acts, from these allegedly criminal acts, up until the jury has ultimately decided one way or the other. That is likely not what Donald Trump wanted in this case, but I think that's where we're going to end up. Let me know what you think in the comments below. For now, my name is Nathan Saunders, and this is The Legal Good.